So, good morning, everyone. Maybe good afternoon to Professor Andres, is in Poland. Uh, I want to introduce you a friend of mine, a great scholar, a great Leibniz scholar, who is Aleksandra Horowska. Sorry if I didn't pronounce it quite well. You told me if it was right. Uh, Let me read you a brief resume from Aleksandra. Aleksandra is a young researcher specialized in Leibniz philosophy of law. Her PhD thesis, which she is writing, is devoted to the concept of obligatio in Hanoverian philosophy. In 2022, Horowska edited and published in Peter Lang a collective volume, The Labyrinths of Leibniz Philosophy, containing articles by Polish and foreign scholars. Horowska has also published several articles and has participated in numerous conferences, including the prestigious Leibniz Congress in Hanover, 2016, the seminar of the Institute of the History of Philosophy at the Department of Philosophy at Emory University, Leibniz Philosophy of Law, 2019, the 13th annual conference of the Leibniz Society of North America at Emory University in Atlanta, 2019, and the 16th annual conference of the Leibniz Society of North America at Princeton University in Princeton, 2022. In 2017, Aleksandra Horowska was also one of the founders of the Polish Leibnizian Society, within which she holds the position of secretary. So, please, Aleksandra, it's an honor for us to have you here, and quiet my microphone, so I give you the word.
Okay, thank you so much, and thank you, Professor Garcia, for inviting me to be key speaker in this seminar. It's an honor for me, and it's my first speech during the seminar organized by other university. So thank you so much. Due to Professor Garcia asking, I prepared for yours something about Leibniz philosophy of law. I'm trying to present Leibniz as someone who may be called modern philosopher of law in the strict sense. Of course, I cannot give you a complex and very detailed presentation about Leibniz philosophy of law, because it is impossible during 50 minutes. But I would like to give something like introduction to this philosophy, to his philosophy of law, and to give you main topics or main subjects, main problems, on which Leibniz wrote in his early legal writings. As you can see, I hope, as you can see, Leibniz wrote a lot of legal writings during his study and study of law and philosophy as well. For example, the first legal text of Leibniz, legal in the strict sense, we can identify this text with his master dissertation, specimen of philosophical questions collected from the law. So we can see that during his life, in the origins of his life, Leibniz was very interested in questions of law on the very abstract philosophical level. My presentation is based on one of the most important Leibniz legal dissertations, that is the new method of learning and teaching jurisprudence, from 67. This is the only Leibniz dissertation which is concerned on the question of jurisprudence, that is science of law in itself. And this text, in opposition to a very large number of other Leibnizian texts, was published by Leibniz, so it was released to the public during his life, and you can ask me why I'm focusing on Leibniz's early legal writings, so on the texts which were written by him before his development of metaphysical as well as theological or physical theories. I can say that we should analyze these texts, these early legal writings of Leibniz, because they contain main principles and concepts of Leibniz philosophy of law, which and these concepts were not changed by him during his life. So these texts contain his main principle and key concepts and conceptions and notions of philosophy of law. And I would like to focus on one of these texts, the new method of learning and teaching jurisprudence, because it's, as I mentioned, one of the most important Leibnizian texts of philosophy, on philosophy of law. So, as I mentioned, it is not possible to give you an analysis of basic concepts of Leibnizian philosophy of law in a very comprehensive and complex way. So I would like to say you about a few of them. That is to give you and presentation of his philosophy of law and jurisprudence in general, and the main concepts of this science of law. So right, obligation, subjects and objects of right and obligation, causes, so sources or foundations of them, and the conception in a nutshell, the conception of natural law, which was presented by Leibniz in the New Method and in other texts in a very similar way. So, philosophy of law. I can say that Leibniz was a philosopher of law in a very strict sense. What does it mean? He often give us an opposition of philosopher of law and empiricist. So we can say someone who only practice law without comprehension and very understanding of legal problems in an abstractive way. And Leibniz in Nova Method, in the New Method, and in other legal texts, Leibniz highlights or emphasizes that we should our approach to legal problems has to be based on metaphysics and theology, as well as logic, or we can say epistemology, because law, the sphere of law, or the sphere of rights, in English it's always very difficult to distinguish between law and right. We can say this is important, very important difference, especially in Leibniz philosophy, because law, lex in Latin or loi in French, can be understood as positive law or law in general, in a very abstractive way, and in this meaning it can be identified with Latin use, and right is to be understood as law in general, as use, but in this context it means that it means subjective right. For example, we can say that American government created the law or statutes or constitution or something like this. So the law in the sense of positive law, and we can say that we as persons, as human beings, possess rights, natural rights, for example, rights of to live, rights to have opinions, rights to free speech and similar similar rights. So that's the difference, and this is the difference which is crucial in Leibnizian philosophy. So when we say when we are talking about philosophy of law, we are talking about philosophy of law in general, that is abstractive sense of law, as positive law, as natural law, as eternal law, as jus gentium, so law of nations. So this is the very abstractive approach to the problems of law. And in Leibnizian philosophy, philosophy of law derives from his theology, from his metaphysics, from his logic. Because, as I suppose we will see, ontological structure of world is in congruence, or is similar, or determines the ontological structure of law. The crucial point of this point of view is that principles of universal world, as for example principle of reason or principle of continuity, can be identified and applied to the science of law. So there is a strict connection between the ontological structures of being in general and ontological structures of law, of rights, of norms, of subjects of these rights and obligations. So Leibniz often emphasize that if we really want to understand legal problems and find the best solutions in concrete cases, we have to reflect on law in a very abstractive way, and that's I can say the key point of his philosophy of law. I'm talking about it about the subjects in briefly way. So for me, it is the crucial element to understand Leibnizian approach to the problems of law. So we can start with the conception of Leibniz's conception of jurisprudence. Jurisprudence is defined in two ways in the Nova Methodus. In the first paragraph, Leibniz writes that jurisprudence is the science of law connected to a case or fact. What does it mean? Firstly, jurisprudence is the science, scientia. It has a very serious a very serious consequences, because science, as you can see, is understood by Leibniz as a system of propositions which are necessary, universal, and which are probable from the terms themselves. So it is jurisprudence as the science can be considered the science, the a priorical science, the science a priori, because there is no facts in jurisprudence on the on its highest, more general, the most general level. And that's why Leibniz writes in later than the new method text, Elements of Natural Law, that the doctrine of right, here we can say also the doctrine of law, belongs to those sciences which depend on definitions and not on experience, and on demonstrations of reason and not of sense. They are problems of law, so to speak, and not of fact. When we consider, when we're reflecting the structure of jurisprudence, Leibnizian jurisprudence, we can identify the main concepts or notions, definitions which are built on these terms and concepts and notions. And from these definitions, we have we can derive propositions, and from these propositions we can derive the next propositions, and the next, and the next, and the next, and the next. So the whole system is created by Leibniz more geometrical. So in the way which has its origins in Euclid's Elements. Of course, it's not. It's a project. Leibnizian jurisprudence is a project, so we can observe that he never has created the jurisprudence as the strict science similar to maths, as he planned. But his purpose was to to construct jurisprudence from definitions, from concepts, definitions, and propositions, which can be derived from these definitions, and further propositions. So for him, jurisprudence is not an empirical science, but pure a priorical science, which can be compared to maths, mathematics, but is not as perfect and certain as mathematics, of course. But the very important thing is that for Leibniz, the science of law, as a very abstractive approach to the problems of law, is not is not the composition of mixed facts. I mean that, for example, the facts of real norms created by a state. For example, if we mixed, if we gather together and mixed norms from actual states and countries, the result of this is not a jurisprudence for Leibniz. Of course, jurisprudence in its historical perspective is connected with the norms and laws and status of our communities, but it is not essence of this science, because this is the science which is based on principles and propositions which can be derived from these principles. So this is the science. This is a priorical science, and this science of law is the science of the law connected to a case or a fact. So we have the normative dimension, so the dimension of law, which can be applied to the empirical or real dimension, so dimension of cases and facts. So the real situations in which law should be applied to. And that's the first definition of jurisprudence. The second definition of jurisprudence from the new method is that jurisprudence can be identified with the science of the actions insofar they are called just or unjust, or unjust or unjust. What's the difference? The difference is only in the perspective of definition, because there is no opposition between these two definitions. The first definition can we consider as more objective, and the second more subjective, because the first definition is in the context of the first definition, jurisprudence is the science of law, so we can identify its object. And in the second definition, jurisprudence is the science of actions. So it's the science of actions provided by subjects, so mainly human beings, and these actions must be or have to be identified as just or unjust. So it's the very serious limitation, because jurisprudence is not the science of the actions in general, but only the actions that can be how to say, that can be that can be identified on the legal dimension. So the dimension of justice and injustice, and the dimension of right and obligations. And Leibniz often boils in his texts chains of definitions. The second definition of jurisprudence can be considered the instance of this approach, because we have the definition of jurisprudence, and in this definition appears the concept of just or unjust, and so on. Leibniz has to define what does it mean to be just or unjust. And he identifies justice or injustice of action with usefulness or harmfulness, but not in a concrete individual way. But he writes that just is defined as whatever is publicly useful, and unjust, which is publicly harmful. What does it mean? This is the crucial point of Leibniz jurisprudence, because we can see that his jurisprudence is in fact universal science, because as he writes publicly, that is firstly for the world and for God, who is its rector, and secondly for mankind, and finally for the state, which is subordination in case of conflict. The will or the utility of God is to be preferred to the utility of humankind and to this utility of the state, and this to one's own utility. Hence we can speak, one may speak of divine, human, and civil jurisprudence. Divine jurisprudence is also called universal jurisprudence. So in this conception, Leibniz connects justice with usefulness or utility. Of course, it's not. Of course or not, it's not utility in the sense of the later Bentham conceptions. It's utility which can be compared to common good, or the optimum state of beings. So it's the utility understood in ontological way, I think. So in this second definition, we have the subjective approach to the jurisprudence, which can be identified as the science of the actions and what are the subjects of these actions. the subjects of these actions are the moral or legal subjects, which who Leibniz defines in another section of the new method. And justice of these actions is in fact connected with utility, which is understood by Leibniz as the common good, or the optimum state of reality. In the new method, Leibniz provides us the sub-disciplines of jurisprudence. What is important here? It is important that Leibniz distinguishes between didactic or positive jurisprudence, which includes rules that are explicitly contained in the legal status of countries, of folks, of nations, and he says that they are of certain right because we can identify in a very clear way the sources of these rights. For example, if we are searching the source of right of equality, we can, for example, take the constitution of a state, and so we can identify the right in this source, which was created by the authority of one of the states. And didactic jurisprudence is something different from the polemical jurisprudence, which Leibniz defines as the part in which contains cases not covered by the laws, adopting reason and similarity, which defines these cases. So in the polemical jurisprudence, which is, I can say, the most difficult, or as well as creative jurisprudence, we have in this part of jurisprudence, in this part of jurisprudence, we don't have the obviously expressed rights by the positive law. We have cases that are difficult to solve because there is no certain right. So we should use another instruments, another tools to solve the legal case, and these tools are reason and similarity. Reason, so the abstractive reasoning to solve legal problems, with adoption of logical principles and logical ways of thinking. And similarity, argumentum ad simile, assimile. The argumentation which is based on similarity between the case that should be resolved and another cases to which there is a certain law which can be applied. So, for example, if we have a very complex, serious problem to which there is no positive law, because, for example, it's a very new cases. For now, we can think about problems of artificial intelligence or something like this. There is no law which can be applied to it. So we can looking for the similar cases to which there is a law which can be applied to, and that's the tool of similarity, and that's the another then reason, but in accordance with this reason, instrument of solving legal problems in the theory presented by Leibniz. So we know now what jurisprudence is and what the science of law is, because jurisprudence is the science of law or science of rights, if we are thinking on it in the subjective way. So now we should identify, determine or define the crucial notions of jurisprudence, so right and obligation. Leibniz writes this way: morality, that is the justice or injustice of an act, derives, however, from the quality of the acting person in relation to the action springing from previous actions, which is described as moral quality. But just as the real quality is twofold in relation to action, the power of acting and the necessity of acting, so also the moral power is called right, the moral necessity is called obligation. The first point is that the notions of right and obligation are strictly connected. There is no, in a shortcut, there is no right without obligation, and there is no obligation without right. In general, that is the general principle. We have also exceptions, but in general, if one person possesses a right, another person or another persons possess the obligation which is joined with the right of the first person. I can give you an example later. Right, that is used in Latin, is the power of acting. I don't. In my opinion, it's not the very good translation. I prefer the capacity of acting or possibility of acting, because potentia is not the power in this case, it's rather the capacity of acting. So we can say that if we have right, we have the power, of course, but in fact we have the capacity for action. And the necessity of action can be identified as moral necessity, so the obligation itself. The obligation in Latin is obligatio. It has a lot of meanings. In this case, obligation can be identified with something like duty. So necessity of acting in a very strict, determined way. Leibniz calls rights and obligations moral qualities. Moral qualities, it's an expression used by Grotius in his De Iure Belli ac Pacem, his main work. And so Leibniz derives this conception from Grotius, but his conception of right and obligation, as compared to Grotius, is, I can say, more logical and more abstractive. So Leibniz provides us the more sophisticated, in my opinion, theory of moral qualities than Grotius. But of course, we should have in mind the Grotian origin of this Leibnizian theory. Who can be identified as a person, as the subject of right and obligation? That's the new conception, because before Leibniz, if we were talking about law, about rights and obligations, we were talking about persons who possess these rights and obligations. Leibniz introduced to the theory of law the concept of subject of right and obligation. So subject, not person, more abstractive notion and more abstractive approach to the legal subjectivity. So we can say that Leibniz was the first who gave the theory, the conception of legal subjectivity in the very modern way of thinking about or on legal problems. And the subject of moral quality is twofold: is person and what is surprised, a thing. Person is identified by Leibniz in the very classical way as rational substance, and this rational substance is either natural or civil person. And natural persons are God, angel, and man. God has, of course, the special positions in the science of law, in the jurisprudence, because this is the only subject who possess only rights and no obligations. All other subjects of rights and obligations possess rights and obligations. So the position of God is special, not only on the level of Leibniz metaphysics, but also on the level of his philosophy of law. But it is, in my opinion, it is important to notice that God is, in fact, not equal, but is placed inside the system of law, next to angels, next to human beings, and maybe other intelligent beings who possess reason and will. So there is a very complex way in which Leibniz considers the legal subjectivity, because we have a lot of legal subjects, as we can see, not only human beings. In another text on persons, which is unfortunately undated, I think, Leibniz defines persons as someone capable of possessing moral qualities, so rights and obligations, and as a substance who possess reason and will. So we have the two conditions for being a person, so for possessing personhood. The first is reason, and the second is will, which of course is connected with reason. Why this is important? Because for Leibniz, the legal subject, the subject of rights and obligation, has to be a rational subject, has to possess a reason as a capacity of getting knowledge about rights of his own, but also of rights of other persons, and which, as in connection with will, is also the principle of acting. So to be subject of rights and obligations, in Leibniz's view, is to be subject who can identify legal norms, who can identify his own rights and obligation, and who can act due to these legal norms and due to these rights and obligations. So the rational element of personhood, rational element of legal subjectivity is very emphasized by Leibniz in the new method and in also his other texts. For example, the specimen So the master dissertation I've mentioned. So the natural persons in the Leibniz view are connected with rationality, but also with the immortality of the soul, and that's the basis of legal subjectivity of furious men, so madmen, of people being in a coma, so living on a very lowest level of consciousness, and as well as we can say that legal subjectivity is a feature of nascituri, so people who are in the womb before their birthday, as well as dead men, dead people. And this is very very interesting point of Leibnizian philosophy of law, because in the modern contemporary approach to legal subjectivity, legal subjectivity is created by our birth and has its ends in our death. So only living people can be identified as legal subjects. In Leibniz philosophy, not only living people, as we can see, not only people in general, but also the dead people and the people who have not yet arrived at our world. So before birth and before conception in itself. So his conception of legal subjectivity is, I think, the widest possible conception at all. In general, we can say that for Leibniz, if someone, God, angel, living human, dead human, possess soul, so possess the quality of being immortal, in fact, he or she possess the legal subjectivity as well, and can be considered to be the citizen of God, universal monarchy, as Leibniz wrote in his later texts as monadology and theodicy and other texts. So that's the natural persons. And we have also a civil person, and it's the simple case. Civil person is a corporation, guild, collegium, society, corporation, company, and I think that we can provide another examples. And why we can say that civil person in Leibniz philosophy of law possesses legal subjectivity because it it has a single recognizable will through some sign. For example, society or a corporation can vote, so it is in fact an aggregation of people, so of legal persons who possess reason and will, and who can express their will. And the logical consequence is that the civil person, which is consisted of these people, can express its will, so it can be the subject of a legal action, and in consequence it can be a subject of rights and obligations. We can say about for example, obligation of taxes with reference to company. So for Leibniz, a civil person is another example of person as the subject of right. But the more I think interesting thing in the concept of legal subjectivity in Leibniz philosophy is the second type of legal subject, that is a thing. A thing is likewise a subject of rights and obligations. So for Leibniz, a thing is not a thing doesn't have full legal subjectivity and cannot be identified as person because because of lack of reason and will, but it is something similar to person and something similar or quasi subject of right and obligation. And what does it mean for Leibniz? He gives us the example of a horse. And he writes, if something is bequeathed to a horse, for example, trappings, so that's the equipment which is useful for riding a horse, it cannot be doubted that since the horse has been alienated, the thing passes to the new owner of the horse. And the same right is applied to the slave, who is not to be considered as a person but as a thing. So the first example with a horse. To say that a horse is subject of rights or obligation is to consider a horse not as a subject. We cannot say that a horse possesses the right of property to his trappings, to its trappings, but the consequence of thinking about horse as a thing as a subject of right and obligation, the consequence is can be observed during the case of alienation of horse, because if you sell the horse, you also sell the equipment which is connected with the horse. So despite the fact that a horse is not the owner of the trappings, these trappings are connected with the horse, and that's the and that for Leibniz is the legal consequence of thinking about a horse as the subject of right and obligation. But as I think, as you can observe, this conception is not as clear as it should be, because Leibniz defines subject of right and obligation as moral capacity or necessity of action. So he defines it as moral qualities, and then he writes about a horse as a subject of as a thing, so as a subject of right and obligation, so as the subject of moral qualities, but horse as a thing, as a non-rational being, cannot act in the moral way. So we cannot say that a horse acts justly or unjustly, but it is defined as a subject of right and obligation. And that's not a very clear conception of Leibniz philosophy of law, but I think it should be analyzed in a more detailed way, because I think it is important that Leibniz didn't limit legal subjectivity to personhood. And the second example is about the slave. Of course, for us, the slave, as well as for Leibniz, the slave as a human being is not a thing in the ontological way, but on the legal on the legal level, Leibniz talks about the slave as a thing, because in the context of Roman law, slaves were considered to be things. So it's not the thing in the ontological way, but in the legal way of thinking. And this example of slave as a thing provides us, I think, more clear understanding of the conception of thing as the subject of right and obligation, because of course the slave is not legal subject in the strict sense, but we can say that the slave possesses some rights and some obligation, for example, obligation of working for his master. So this is the conception of a thing as the subject of moral quality. The relationship between a right and an obligation, I mentioned that this relationship is very important, because if the one party of the legal commitment possesses a right, for example, a right X, other party or other persons possess an obligation of not to infringe a right X of person A. So the right of one person is connected with obligation of other person or all of other persons, if we are talking about if we are talking about I'm sorry. If we are talking about some kind of laws of law, the object of right and obligation. This is the second very abstractive notion Leibniz introduced to the science of law, and the object of rights and obligation is in the body of subject. So, as I am, such as I am the subject of right, I have the right to my own body, and this right, this body of mine is the object of my right. But not only my body can be identified as object of right, but also other things or other persons. And the right over my own body as a subject is called freedom, libertas in Latin. And for Leibniz, the freedom is the substantive, most important subjective right of persons. The second is the right in things, which is called faculty. It's, we can say now, the property law. And the third kind of law is the right over a person, and this right is defined as authority, but I prefer to have the to use the original term of potentia, because potentia is not only authority, but also other kind of power over objects, over things. And this right over a person varies in many ways, sometimes of life and death. And this is the life of death of pater familias, that is the most important person in Roman family. And sometimes this is the power of punishment. So, for example, it can be attributed also to the institute of a state, and sometimes of reproach, etc. So that's the three objects of rights and obligations, and the three kinds of law connected to them. Of course, as we observed, with these rights, there are also connected obligations. not to obstructing the freedom, faculty, and authority of another, because if we will not realize this obligation, we will make an injury, and the kinds of obligations are not so important for Leibniz. That's the schemas of relationships between rights and obligations, and the causes of rights and obligations. I don't know, Professor, how much time have I?
Actually, we'll lack of time.
Okay. Sorry. So I would like to say that there are two main causes of rights and obligations: nature and action. And action can be identified with possession, with injury, and what is very important, with an agreement. So we can say that in Leibniz philosophy of law, the agreement can be considered to be natural source of positive law. Because the two causes of rights and obligations are natural causes. So nature is natural cause of rights and obligations, and also action is natural cause. And also the agreement is the natural source of law. So we can say that if we have rights and obligations which can be derived from, for example, constitutions of our states, of our countries, these constitutions are derived from agreements as the natural source of law, and that's the conception. This conception is very interesting because it's similar and influenced by conception of Thomas Hobbes, and the whole new method on which I'm talking about. Is the dissertation in which the influence of Hobbes on Leibniz as the philosopher of law is very clear and possible to identify. And the element of agreement in Leibnizian philosophy of law as the source of our norms, of our rights and obligations, this element of agreement is the Hobbesian element in Leibniz philosophy of law. And the consequence of this conception is that we must keep his promise. So we must obey the law of our states, because the source of this law is not positive, it's natural. So nature is the source of positive law, and that's the reason of our obeying the positive law, which in Leibniz point of view is not very is not perfect, and it can be unjust, but it's the normative order which is valid and which provide us principles of actions. So the young Leibniz emphasized that positive law has its origins in natural law, and natural, which on the other side, on the other hand, is perfect. So this is the very interesting thing for contemporary theory of law, that there is a justification for positive law in the natural law in Leibniz. I don't have time to tell you about natural law, which is very interesting concept in Leibniz, and this is the concept also contained in the new method. But I must finish. So thank you so much for your attention, and maybe we have time for questions.
Thank you, Aleksandra. Yes, we have a couple of minutes. If there is someone who wants to ask something brief, maybe. Daniel, yeah.
Thank you, Aleksandra. That was a very fascinating talk. I was very interested in the things that you were saying towards the end. So just wanted to hear, I'm curious to hear your opinion about the following. Do you think that modern and contemporary debates about the origin of law and this use positivism versus use naturalism conflict that seems to be already present, you know, in how philosophy of law is expressed, do you think Leibniz could have resolved or give a solution to that problem that could be satisfactory for both parties?
I don't know if it's satisfaction for both parties, but certainly Leibniz provides us the solution of this problem. In the new method, it is expressed in the determination of positive law by the natural law. So and in the principle of privality of prevail, natural law on positive law. So in principle, in general, we should obey, in Leibniz concept, we should obey positive law, but in the case of conflict between the norm of positive law and natural law, we should take the norm of and obey the norm of natural law, because this it is perfect always. It is the norm which is derived from the basic principles of the science of law in general, and this is the norm that always prevails. But of course, Leibniz was very flexible in the cases of legal problems. So the solution is always determined by the concrete situation. But in general, there is a principle that natural law prevails positive law, which doesn't mean that something without justification, without reason, because it is valid for Leibniz. But but we should always looking for the optimum, and natural law is always in congruence with the optimum. Positive law can be, but not always. And there is also in your question is also another question, because the natural law has 2 degrees in Leibniz philosophy. This is degrees of jus strictum, equitas, and pietas. I don't have time to explain it, but there is also the principle that pietas prevails on equitas and equitas prevails on jus strictum, but each of them possess or contains in itself the lower degree. So in pietas there are jus strictum and equitas, and in equitas there is a jus strictum. So the conception of natural law in Leibniz is complex. So we can say that natural law prevails positive law, and in natural law also the norms of higher degree prevails on norms of lower degree.
Thank you. That makes very good sense to me. If you could tell us towards the end where we can, because it seems as though you had very many more interesting things to say about this. So if you could tell us where to find some of your, some of these ideas you're presenting to us, that'll be fantastic. Thank you so much.
Where to find? You asked me
where to find more of your work.
Of mine. Okay. So
Professor Roberto told us that your profile in academia.edu seems to be very well shaped.
There are there is two articles that are accessible on the internet, and they are in English, so you can find them. But I don't know if I gave you the titles, so I can send it by email. And there is also my collective volume, in which which contains also my article about the similarity between jurisprudence and theology, which is also one of the concept of the expressed in the new method. But I can recommend also a lot of works provided by other Leibniz scholars. For example, Professor Ursula Goldenbaum, but she wrote in German, I think. But she's the specialist on Leibniz philosophy of law and moral philosophy in general. And in the context of Leibniz philosophy of law, I recommend the book of Christopher Jones. I can give the title in the email, but sure. It's the Kantian interpretation of Leibniz philosophy of right, which in my opinion is not correct, but it's very interesting, and the analysis provided by Christopher Jones is very detailed. So if you are interested in, you can check it in the book.
Thank you.
You're welcome.
There's also a question, Professor Andres.
Yes. Thank you very much for this very interesting and thorough presentation. So I have a question regarding the second definition of jurisprudence. You mentioned that it is the science of actions insofar as they are just and unjust, but that just or unjust are defined in terms of being publicly useful and harmful, but that this is not useful, should not be understood in terms of utility as in pleasure, right?
Yes, it's not useful to to understand this notion in the 19th century way of define utility, because because Leibniz talks about the optimum state of things, which can be which from the perspective of subjects is useful, because we can find our own happiness, our own perfection, and our own utility in the utility of all the community, universal community on the highest level. So
but, yeah, my question was if account of utility is, you know, in some sense it's also it could be understood as utility in the utilitarian sense, insofar as this common good, this optimal state. I suppose if it includes like the maximization of happiness as in pleasure, right, or some form of the reduction of harm, then it would be some form of utilitarian principle, right? And I was wondering if the same could be said. This wasn't mentioned in the talk, but I was curious about if, you know, because if I understand correctly, Leibniz God is he considers a lot of possible worlds and chooses to actualize this world because this is the best. And I suppose part of being the best is that it doesn't have like the greatest amount of suffering, right? So could Leibniz be like in some way like a proto-consequentialist philosopher?
Consequentialists?
Or utilitarian, I mean that by utilitarian in the sense of pleasure.
No, I don't think so. Your point is to reduce this kind of thinking about utility by Leibniz to the utilitarianism way of thinking about it. I don't understand you.
Well, not to reduce, but I suppose it includes this. If
it includes. Okay, we can say that it includes, but it is not reduced to this way of thinking about utility, in my opinion. But because I don't see any important contradictions between these theories, but Leibnizian approach is more complex, I think, that this of utilitarian.
Okay, I see. Okay, that's very useful.
If you would like to consider this question most broadly or deeply in the more deepest way, there is a good translation of Leibniz legal writings provided by Professor Hubertus Busche. It was published by Meiner Verlag, and there is a good introduction to these fragments from the new methods and through the elements of natural law. And if I understood if I understand, if I remember, there is also the exemplification of the or explication of the question of utility. But it's interesting because because of course this conception evolves the conception of utility in the 19th century, but there are similarities, but it cannot be reduced to this conception.
I see. Thank you very much for your answer and for the recommendation. Yes.
Thank you.
We also have some Spanish translations. The Elemental Juris is translated by Tomás Guillén in Tecnos, and also, well, it's not already published, but me and Professor Juan Abelardo, as Andres, you can remember,
Yes, yes.
we have a translation of the Nova Methodus.
Okay, that's.
So I can share it with you if you like.
Yes. Thank you very much. That would be great. Yes.
Oh, sorry. Sorry, Professor. I didn't know about it, but it's very, very interesting that that there is also your translation. And have you analyzed? Have you ever analyzed the conception of utilitas in this translation?
No, what I really like the most about the Nova Methodus is that he defined the moral quality, and this is also related with the definition of personal identity that he established in the new essays. So I'm more liking that a practical approach to personal identity, because maybe it's the only place where he defines moral quality, as far as I know. Explicit terms.
Personhood, yeah.
Yeah, because in the new essays he say that personal identity consists in moral quality. And there are several texts, metaphysical texts, where he used to make this association or this definition of personal identity.
Yeah, I can agree with it. I can also add that in Princeton I had a speech about the possibility of animal rights in this Leibnizian theory, because it's important as animals. It is important to determine if whether animals possess legal subjectivity, because they are res, so they are things. There are things, and things are conceived as legal subjects. They have immortal souls, but not rational souls. So there is a tension between the definition of legal subjectivity and personhoodness and personhood, the definition in the terms of rationality and volitionary, because it must be reason, but it must be also the will as well. But on the other side, we have this very early conception of things as subjects of moral, as subjects of rights and obligations, which is not very clear, because things cannot be moral subjects. So why Leibniz defines it as, perceives it, these as subjects of obligations or rights. My understanding of this problem for now is that, or my approach is that maybe it would be useful to apply to the conception of legal subjectivity in Leibniz theory the principle of graduality, which derives from principle of continuity. So, as on the ontological level, we have a chain of monads, chain of consciousness, and principle of continuity with no radical, very radical, with real but not very radical differences between substances. Maybe this perspective would be useful for the perspective of legal subjectivity. Maybe we can say that despite the fact that animals don't possess reason and will, they are similar to rational substances. So maybe they possess something like similar to legal subjectivity, quasi-legal subjectivity. That's another interesting point. So sorry.
There are some approaches about that in Ibero-America. Some Ibero-American Leibniz scholars, like my PhD director, who tries to make an apology of Leibniz conception of animal rights through his notion of pleasure, and it's maybe an tolerantist approach of Leibniz. I don't really agree with that at all, but I know that there are some other Ibero-American speakers who tries to defend the animal rights by ascribing animals this kind of notion like pleasure. If they feel pleasure and pain, they have rights, and they say Leibniz defends that they have some phenomenal consciousness, so they can experiment pain and pleasure, so they maybe have some rights. That's why what they try to argue. But it's more more like Peter Singer approach. So I agree with you that his notion of pleasure and his notion of utility is not the same as the utilitarianism.
Yes, and in this point, I totally agree with Professor Goldenbaum, who argued that, of course, Leibniz observes and claims that that animal can suffer, but it is not the principle for providing them rights. So there is no logical inference between the fact that that animals possess ability to perceive and to perceive pleasure and pain, and the possessing of rights. In Leibniz, there is no inference logically. So it is a problem, but it's very interesting. Leibniz is very, I think, it's very. It could be useful for contemporary theory of environmental rights and animal rights. It's interesting. Sorry.
No, thank you, Aleksandra. There's a last question of Dan Espejel. Please, if you can make a really brief question, Dan.
Hello, can you hear me?
Yes.
Yeah, okay, perfect. Fritz, thank you for your presentation. It was very interesting. Thank you for that. I had a little bit question. Maybe it's not a good question, but for me, it's important to clear one point. What do you think in the Leibniz theory of law? Do you think what is most important for Leibniz, rights or obligation for the correct relationships in the society, or do you think are in the same level?
Okay, I think that's, but it's my interpretation. I think that the notion of right is strictly connected with the notion of obligation, but it's more from the logical point of view. It's maybe more primary. More primary in the sense that what could have more sense to finding the source of normative order in obligation, so in necessity of acting, or in rights, so in the sphere of possibility of acting. So what would be primary, possibility or necessity? For me, but I cannot give you the very persuasive argumentation for this, because I cannot find it also in Leibniz text and in my interpretation of it. But for me, the notion of right is more primary, and in consequence more important, because it provides us a sphere of legal acting in which there is also necessity of acting. So the notion of right for me is more important. And the second point is that there is a subject without obligation, that is God, but there is no subject of legal subject without rights. So maybe this is the direction toward which we can argue. So the notion of right and the rights in general in Leibnizian theory of law is maybe more important. I don't know if it satisfied you.
Yes. Thank you so much.
Thank you. Very interesting question, I think.
So thank you very much, Aleksandra. Thank you for your time, and thank you everybody for coming to this session. So
Professor Paniel Osberto is.
I was just clapping.
yeah.
Okay.
Acknowledging the great talk.
Okay.
So we'll take a few more minutes for a question, but that's really okay because we have a great time with you, Aleksandra. Thank you so much for taking this time for the seminar. And well, we have 2 more sessions of the seminar. The next session is going to be about Conway. So it's also going to be quite interesting session, and the last one is going to be about enlightenment, a conference about from Roberto Rodriguez Aramayo. So, Alexander, I will send you a certificate from the university to thank you for your great conference. And if you allow me, also I want to put this video on YouTube if you authorize me. If you don't, I will not. Right.
If it's the if you would like, I don't see the obstacles for it.
Great.
So please, as you wish.
Thank you. So thank you very much again. Well, let's see you. Maybe, hopefully, we can meet in Hanover next year. Hopefully.
Yeah, I will be there, and I hope you too.
Thanks.
Okay, thank you very much, Professor, for invitation for the seminar. And sorry for the time of my presentation. I didn't meant to be so long. So sorry, but thank you also to the participants for your attention and very interesting questions. And so as I have spoken, I can give you a little by email a literature about the subject, which is very interesting in itself.